Hey, what's good, everybody? Welcome back to the channel. This is Carl from Sovereign Citizen Chronicles. All right, today we're going to be in the courtroom of Judge William T. Burton out of the state of Michigan. All right, he's going to be going up against a sovereign citizen who was actually convicted of murder, and he's facing charges now of, I believe, an assault or attempted murder with a dangerous weapon, with a handgun. All right, so let's get to this proceeding.
Mr. Reynolds?
Judge, what was that preliminary exam date? You said 12/27 and then 1.
January 3rd.
And yes, we're ready,
Mr.
Judge.
Reynolds?
Yes.
Okay, Mr. Reynolds, state your name.
Your Honor, if I could probably clear this up, Mr. Reynolds is objecting to a video arraignment at this time.
Mr. Reynolds, state your name.
Erving Reynolds.
This is case number 240608. Mr. Reynolds is being charged with count 1, felonious assault. Did make an assault upon Elisa Jordan Smith with a dangerous weapon, to a pistol, without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to MCL 750.82, a 4-year felony and or $2,000 fine. Count 2, weapons felony firearm. Did carry or have in his possession a firearm, to it a pistol, at the time he committed the committed or attempted to commit a felony, to it felonious assault, contrary to MCL 750.227B. 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device. Count 3, domestic violence. Did make an assault or an assault and battery upon Alyssa Jordan Smith, an individual with whom he had a dating relationship, contrary to MCL 750.81 subparent 2. That's a 93-day misdemeanor and or a $500 fine. A consecutive sentence may be imposed on MCL 750.506 sub small a if the assault was committed in a place of confinement, as well as habitual second offense notice. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
And again, Your Honor, Sydney Rushing, P78830, on behalf of Mr. Reynolds. And again, Your Honor, I'd just like to advise the court, my client is objecting to a video arraignment. You would like to be arraigned.
Noted for the record. Noted for the record. Bond recommendation, Mrs. Coyle.
Your Honor, based on, he's currently on a parole hold. He has a parole violation, is returned to MDOC for he has a murder 2 out of 1992. He got 25 to 40. He was paroled in April of this year. This occurred in October of this year. As the court notes, it's highly assaultive, threats of death, with a weapon. The complainant's statements are corroborated by the officer noticed a scratch under her chin. Also, they found the weapon in the backyard where he was detained once he fled from the officers. So for these reasons, Your Honor, although I know he's on a parole hold, he's likely going nowhere based on the allegations, based on the assault of nature. And I believe my guess would be the violation is the new case, but I'm not sure. So I'm going to ask for $50,000 cash surety and a tether if he is released, tether house arrest. But likely, I have a feeling this is what the parole is about.
Ms. Rushing?
Your Honor, we'd be asking Your Honor to consider a lower bond. That is an unaffordable bond. Again, my client is located at the Michigan Department of Corrections currently. So we're asking you for consider a lower bond. I believe a GPS tether is the least restrictive means if Mr. Reynolds is able to be released prior to the conclusion of this case.
Okay, for clear, convincing reasons, I find Mr. Reynolds a danger to the complaining witness and to the community.
Yeah, that was very smart of this judge, because this guy seems like he's definitely somebody I don't want, out and about in my community, around my kids or my wife or, my loved ones or anybody. This guy's went to jail for murder. He's out. He's back in trouble, and it's a violent offense. And I don't think even with a bond, as far as I know, when you have a parole violation or a parole sticker, even if you pay a bond, you can't get out because they're trying to keep you, incarcerated. But I could be wrong. but even if he makes bond, he would be on house arrest. So I'm glad the prosecutor asked for that. I'm glad the judge agrees, and let's see where this goes. Oh, and the whole fact that he doesn't want to get arraigned on Zoom, I don't understand, what the deal is with that. An arraignment is an arraignment, whether he does it in person or on Zoom.
Based on a review of the investigator's report, there was an assault with a pistol. And then what is troubling, in the last sentence of the first paragraph, the victim stated, "He has my gun and he said he's going to kill me." And given his prior murder conviction, I believe he has great ability to carry out the threat. And so for those reasons, I find he's a danger to the community. I'm going to adopt the recommendation of the people, $50,000 cash surety. While his case is pending, no, he's not possessing any handguns, firearms, other dangerous weapons, no contact with Lisa Smith. If he's able to post bond,
Excuse me, Your Honor. Excuse me, Your Honor. I don't mean to be rude and interrupt, but
it's too late for that. It's too late for that.
Well, I mean, y'all got a whole other thing going on here. She don't represent me. She not my.
Okay. Give me one moment.
Yeah, so that just goes to show you how foolish my man is. Not the prosecutor, but his public defender is actually trying to get him a better situation, a lower bond. I think that he would still have to do the house arrest thing, but at least he won't be incarcerated. So for him to jump in and say that she doesn't speak for him or that she's not representing him is kind of detrimental to probably him wanting to try to get out of jail.
Woo! Fun Friday. Okay. Okay, Mr. Reynolds, I just want you to listen. You're given a $50,000 cash surety bond, which is, I presume, an unaffordable bond. I find that you're a danger to the community. You'll have a bond redetermination hearing Monday, December 23rd, in front of Chief Judge McConaughey. Where you have a bond return. That's 9 a.m. in front of Chief Judge McConaughey. Probable cause, December 27th, preliminary examination, January 2nd, in front of Judge Sabri. You have any questions regarding your bond conditions and or court dates?
I have a question concerning, what is this proceeding? Is this an arraignment?
Yes.
This is an arraignment?
You just been arraigned.
Okay, the thing I'm trying to explain is she not my attorney. She don't represent me. Okay. She been speaking on my behalf, and she not my attorney.
All right, who's your attorney then?
I'm representing myself, and I'm making a special and limited appearance.
What's your bond argument? What's your bond argument?
I don't have a bond argument. I'm making a special and limited appearance. Just to challenge the subject matter jurisdiction of the court. And I'm telling you, this court don't have jurisdiction of the principal subject matter, which is the attachment action that the prosecutor filed.
All right, y'all. So that's the end of that first proceeding. Now we're going to the courtroom of Judge Williams out of the state of Michigan. I'm sorry, I could not find his first name, but his name is Judge Williams out of the state of Michigan. All right. He's also going to be going up against Erving Reynolds for the same case. And there's going to be a dispute about the arraignment from the first case with Judge Burton. So let's get to this proceeding.
I think we're ready to roll. The gentleman that's in the Michigan Department of Corrections facility, can you tell me your name?
My name is Erving Reynolds.
All right,
and,
thank you.
I'd like to say that coming in, that I'll make a special and limited appearance just to challenge the subject matter jurisdiction of the court. And I'm saying that the court doesn't have jurisdiction of the principal subject matter, which is the writ of attachment that the prosecutor's office filed.
All right, your objection is noted. 1 second here. All right, this is State of Michigan versus Erving Reynolds, case 24060877001. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Good morning, Judge. Steve Vincent for the people, P71917.
Good morning, Jessica Shipe, number 81798. On behalf of Mr. Reynolds, sir, can you please state your full name for the record?
She's not my lawyer, Your Honor. This is an arraignment proceeding, right?
Mr. Reynolds, do you wish to represent yourself?
Is this an arraignment proceeding?
This is sort of like an arraignment. This is like a you are arraigned, and this is a hearing to see if the bond.
Hold on, you said I was arraigned?
Okay. So
did you just say I was arraigned?
Your Honor, may I step in? I see some notes here.
Well,
I haven't been arraigned.
Can I stop everybody right now? Ms. Shive, if Mr. Reynolds is indicating that he's not your attorney, then I'm going to ask that you hold tight right now. Mr. Reynolds,
I haven't been arraigned.
Sir, listen to me for a second. I'm trying to straighten this out. You indicated that you have not been arraigned?
Mm-hmm.
All right, 1 second. Let me take a look at what's in the file. Hold tight.
Yes, and I do have notes, so not on behalf of him, just to help the court.
I appreciate that. But
yeah, so we just watched this guy get arraigned in the previous proceeding. So I don't understand what he's talking about. He has to know that he was arraigned because they told him, and now he's trying to play some games. So let's see where this goes. Let's see how this judge handles this.
let me see where we can get to. Hold tight, Mr. Reynolds. I have to look something up real quick. All right. So the system says that it was arraigned, but if that's a mistake, Ms. Shive, you indicated that you had some additional notes.
Yes, so the notes that I have, it looks like Mr. Reynolds did want to represent himself. He was spoken to and told his rights and all. And it looks like he was Okay, it looks like he was objecting to being arraigned without being brought in person. It says that he wanted to be arraigned in person and he was objecting, but I do see that a bond was given and new dates were given. So it said no video arraignment. So I believe it was done without, he wanted to come in person.
Well, I would say this, Mr. Reynolds, I would say this, that's fair. If you want to be arraigned in person.
Hold on, wait a minute.
No, stop. You have the right to be arraigned in person.
They cut
Listen to me. I'm going to stop your audio because you're not listening to me, and I'm not going to go back and forth with you. I'm indicating if you want to be arraigned in person, I am going to order you arraigned in person. And we're going to stop all this. If you stop talking over me, we wouldn't have this back and forth. All right. So I'm going to set an arraignment date.
Yeah, I don't understand why Judge Williams is doing this. They're pretty much, I mean, maybe he does have a right to in-court appearance, but it seemed to me that in front of Judge Burton, he was already arraigned. So if he's going to undo what Judge Burton already did, it just seems like it's kind of wasting the court's resources. Kind of surprised by this, but, let's see where this goes. It's kind of weird to me that he was arraigned. We watched him get arraigned, but I guess because he was like, yo, I'm representing myself. And I don't agree with the arraignment. I guess they're going to give him a whole nother arraignment, but in person this time.
Let's see, today, the next date they have in front here for, looks like there's an exam date scheduled for January 2nd, 2025. We're going to have the writ signed for you to be arraigned on that date. We'll see if that's enough time to transport you to 36th District Court for your arraignment, and then we'll take a PCC from there. So we'll schedule this for an arraignment January 2nd, 2025 before Judge Sabri. That's going to be your next date, and we're going to have a writ to bring you down to 36 for that hearing.
All right, y'all. So we came to the end of that proceeding. Like I said during the video, it's kind of strange that Judge Williams is going to undo the arraignment and give him another in-person arraignment when he's already been arraigned on the Zoom. I mean, maybe because he said he was representing himself, the lawyer did not speak for him, or the public defender did not speak for him. Maybe that gave him a leg to stand on. But he has some serious charges, and he's been convicted of a serious charge, which was murder. So I'm just surprised that they're giving him any leeway, but there must be some type of technicality that they have to follow. Uh, and that's possibly just to make sure that, if he is convicted, they don't give him, a chance to appeal the conviction because of that situation. All right. Anyway, I just want to thank you for watching. Like, comment, subscribe to the channel. Also, hit that notification bell so you get notified when I upload more videos. I catch you on the next proceeding. This is Carl from Sovereign Citizen Chronicles. God bless. Peace.